Maybe it's here.
Why is she the one that we see over there?
I don't know. Hopefully everybody can see me and hear me. If not, then we will let us know. And once again, just type down in the chat box and we'll get it fixed. But hopefully everybody can see us and hear us. And good morning, everybody. Welcome to our webinar for this month of May. Hope everyone's excited for our summer that's coming up and the heat that's about ready to hit us. And I'm not sure how many of you are going to be sticking around or going to be heading out of town, but hopefully this summer isn't as hot as last summer, as long as last summer was. Anyway, what we're going to do today is we're going to finish up our topic from last month in April. We talked about the 8 common mistakes that we see in estate planning. And I believe from what Lisa told me, we made it through number 4. And so we still have 5, 6, 7, and 8 to make it through. So we're gonna do our best to make it through those today. And once again, if there's comments, questions, anything like that, just type those in to your chat little icon that you have on your Zoom. And we'll make sure we address those at the end. Of course, if you want to come in for a consultation and you want to sit down and talk about things one-on-one, we're always happy to do that. Always remember, we never charge for consultations. So if you want to come in for that, that's always complimentary. Don't ever hesitate to call us and come in and sit down with us if you feel like that's necessary. So let's go back and just do a quick summary of 1 through 4. Last time we talked about the first 4 common mistakes that we see in estate planning, and the first one was no protection from living probate or death probate. Most of you have a trust. Hopefully all of you from our suggestions last time, you've checked to make sure your trusts are properly funded and all the assets are in the name of the trust. As long as you've done that, then the trust will keep us from going through both living probate, that's while we're alive but we lack capacity and can't manage our affairs anymore, and death probate, that's when we're of course dead and we can't manage our stuff anymore. As long as all of our assets are in the name of our trust, then that will be avoided, and the cost and delay and expense and all this stuff that goes with probate. Number 2 on our list was not keeping up with changes in the law or personal changes. And so our lives change as time goes by, and of course laws change. And we talked a little bit about some of the law changes that might be coming down under the Biden administration, and some of the tax law changes that might happen last time. And so we did cover some of those things. Number 3 was our protection from nursing home costs. And we talked about how that is the #1 expense for the elderly today. And so we discussed a little bit about things that we can do to make sure that we're ready for that event in our lives if we ever need to pay for long-term care expenses. Number 4, we talked about provisions to minimize taxes and some of the law changes that we expect to see under the Biden administration in regards to dropping the federal estate tax exemption amount and maybe even changing some of our capital gains tax laws that have been in effect for a long time. So those were our top 4 we discussed last month, and now we're going to talk about 5 through 8. So number 5 is no protection if spouse decides to remarry. So what we're talking about here is we have a married couple. Okay, so if you're single and you're on the Zoom call today, this really wouldn't apply to you, number 5. But if you're married and one of you passes away, either you or your spouse passes away, sometimes we're worried that our surviving spouse is going to get remarried. And if they get remarried, they may leave all of our hard-earned assets to the new spouse, disinheriting our children that we have. Or some of you on the Zoom call, this might be your 2nd marriage or 3rd marriage, and there might be, you each might have children from a previous marriage. And so we're worried that, you know, if I die and I have kids from a previous marriage, and let's say my wife has kids from a previous marriage, I might be worried that my wife would remarry, disinherit my children, leave everything to her new husband or to her children. And so that's what number 5 is talking about. So how do we address that in the estate planning document? How can we make sure, if this is your second marriage or third marriage, or you have kids from previous marriages, that your surviving spouse doesn't, when she gets remarried or he gets remarried, doesn't leave it all to the new spouse or disinherit your separate children? Well, there's provisions we can actually build into your trust to help mitigate the risk of that. And some of you on the Zoom call, you'll recall that when we set your trust up, we created what's called an A/B trust. And so I'm going to diagram that. We're going to do our screen share here to get up my whiteboard. And I'm going to, I think this worked a little bit last time. And so hopefully it helps if you can see it visually as opposed to just hearing me talk about it. And once again, if there's questions on this as we're going through this, just type those in. I'll make sure we cover those so that it's clear and I'm not just talking over your head and it doesn't make sense. So here you're probably gonna see the back of my head. Hopefully I'm not going bald. But what we did is we created your revocable living trust, your RLT. And let's say you're a married couple, okay? And so while you and your spouse are alive, you guys are in here and you guys are the trustors, which just is a fancy legal word that means the creator of your trust. You guys are the trustees, which is a fancy legal word that means the manager of your trust. And you guys are the beneficiaries of your own trust, which means you get to spend it and use it and access it and do whatever you want to do with the money inside the trust. So that's period number 1 of your trust if you're married. So the two of you are in here and all of your assets, like we talked about, should be inside the trust to avoid probate when death or incapacity occurs. And then period number 2 is what we're talking about here with mistake number 5. Period number 2 is one spouse has passed away. Okay, so we're gonna kill off one of our stick figures here, and we have our surviving spouse. And what the surviving spouse will do, if the trust was drafted this way, if this is how this couple wanted the trust to read and to be drafted, it would say that when one spouse dies, then this trust, basically it goes away. And all the assets in that trust then get divided into what's called an A trust and a B trust. Sometimes we refer to it as above ground and below ground. It's kind of morbid, but people remember it that way. And basically what happens is we take these assets that were in this top trust in period number 1, and we retitle those assets into these 2 new trusts. Now, 90% of the time in Arizona, because it's a community property state, all of these assets are deemed to be community property. 10% of the time we have clients that come in, they've got a prenuptial agreement or a postnuptial agreement, or they may have separate assets they had prior to marriage and they kept them separate. But most of the time, all these assets that go into this trust for a married couple, they're considered community property. And because they're considered community property, we take half of the value of these assets and stick them in the A, and half of the value and stick them in the B. So think of the A once again as above ground spouse. So this is our surviving spouse's trust, and they own 50% of the total value of the assets. So we put 50% of the value of the assets there. This is our below ground spouse. This is the stick figure that died. And we put 50% or their ownership interest in the trust, their 50% over here. So it's 50-50. So if we came up with a real number, let's say when this stick figure person died, the total value of all the assets was, let's make up a dollar amount. Let's say it was $2 million. So 50% of 2, I know it's early in the morning, but hopefully our math is still not too bad here. It's 1 million and 1 million. Okay. So whatever that number is, we just divide it and we try to put half of the value there and half of the value here. Why is it half? Once again, because 90% of the time, all of these assets are community property. And so it's half and half. That's usually how we do that. Okay. So how do these 2 trusts work? How in period number 2, remember this trust is gone because our one spouse died, and this is how this couple wanted this trust to be drafted. And so we have our surviving spouse now. And let's say that each of these spouses had kids from a previous marriage. And let's say they're relatively, young, that they're in their 50s or 60s. And so there's a chance that the survivor could get remarried. And so they were each concerned that when one of them died, the survivor may disinherit the deceased spouse's children or leave it all to the new spouse. And so they decided to make it so that in period number 2, when one spouse died, the trust would divide into this A-B trust. So how does the A and B trust work? Well, remember, the A trust is the surviving spouse's trust. It's their half of the estate. So this is revocable by them. They can change it, they can alter it, they can amend it, they can revoke it, they could get rid of the whole thing. In addition to being able to change the terms of the trust, they can also spend all the money out of this trust on whatever they want to spend it on. They can go to Vegas and put this million on black and roll the roulette wheel and see what they're going to land on. So they can either keep it all in here and spend it and use it during their life. They can blow it, they can spend it, they can use it, they can change the terms of it. So how would this come into play with our number 5 common mistake, which is no protection from remarriage after our first stick figure has passed away? There would be no protection from divorce. So if there's in the A trust, so if the surviving spouse got remarried to Bob the builder and decided, you know what, I'm going to come in and see my estate planning attorney, and I'm going to change my A trust to say that when I die, then I want 100% of my 50%, that's in the A, to go to my new husband, Bob the builder. We can do that because this is a revocable trust. Remember, this is their half of the community property, and they can do whatever they want to do with it. So that's their trust. Now, the B trust is where we get some of that protection from divorces and whatnot. Because remember, this is the deceased spouse's half of the community property. And because that person is dead, when we're dead, we can't change things. And so this is an irrevocable trust. Irrevocable, cannot be changed, altered, amended, or revoked by surviving spouse. So if surviving spouse remarries Bob the builder, comes in and sees their estate planning attorney 5, 10, 15 years after the first stick figure person has died and says, Dave, I want to change all of the trust, both A and B, and leave $2 million, the entire estate, to my new husband, Bob the builder. We would have to tell the spouse, we can't change the B trust because it's irrevocable. But the A trust, you can leave to whoever you want, okay? So that gives us some protection. We can also build, remember, as we back up a second, the A trust, remember, the surviving spouse has access to 100% of it to spend on whatever they want to spend it on. Remember, we talked about going to Vegas and blowing it all, doing whatever they want. Well, the B trust, we can build this in lots of different ways, but typically we make it so that the surviving spouse has access to this money during their life for health, education, maintenance, and support. Health, education, maintenance, and support. And we can also put in this B trust over here that the surviving spouse cannot be the trustee, the manager of that trust, if they get remarried and don't get a prenuptial agreement before they get remarried. Then they can lose their right to be the trustee of this trust. So maybe, let's say, once again, let's say I had kids from a previous marriage, my wife had kids from a previous marriage, and we draft it. So period number 2 says, if my wife, I die, if my wife gets remarried and she doesn't get a prenup before she gets married, then she loses her right to be the manager of this trust. And maybe one of my kids becomes the trustee of the B trust. So anytime my wife wants money, remember, health, education, maintenance, or support, out of the B side, she has to go to the gatekeeper, my child, and ask for money. And so we can structure a lot of kind of neat things into that B trust to protect the deceased spouse, the first one to die, their half of the estate, if surviving spouse does get remarried, or maybe we have kids from separate marriages, and at least protects their half of the estate in those things. So that's kind of how we can protect from remarriage and divorces and stuff like that. Hopefully that made sense. I know my drawing is not, maybe it's pretty. But hopefully it makes sense you're looking at. So anyway, that's number 5. Let's go back to our 8 common mistakes and talk about number 6 here on our list. All right, so number 6, as you look here, is no protection for estate if children get divorced, go through a bankruptcy, or get sued. So let's go back to our whiteboard, and we'll finish our diagram here. So remember, if we're married, our trust potentially could have 3 different time periods. Period 1, we're both alive, we're in charge, we control it, we spend it, we use it. Period 2, if this is how you wanted to draft your trust, we can make it so that when one spouse dies, the trust divides into an A-B trust, maybe to protect the B trust over here from a remarriage of surviving spouse, or maybe children from separate marriages that we had. And then period number 3 would be what we're talking about in number 6, or mistake number 6. And that's when both spouses have passed away, okay? Now, if you're single, your trust we skip period number 2, we just kind of wipe out period number 2, and we go right from period 1 to period 3, right? So if you're single, there's no period 2, just goes right from period 1 to period number 3 that we're going to talk about now. So in period number 3, if you're single, you've died. If you're married, both of you have died, okay? And so if you're married, then the A and the B trust, if this is how you drafted it, would come back together here into a pot, into a pot. And so we have our 2 million back. And then that 2 million would be divided out. Let's say we've got 2 children here. Okay. And this is going to be our son, Charlie, and our daughter, Deborah. Okay. So then the 2 million comes down. We love our kids equally. We want each of them to get $1 million. Okay. Half of the estate each. Okay. Now, once again, if you're single, you died, 2 million is here. If the size of your estate was 2 million, and then we just divide it between your 2 kids. Okay. So how do we protect our son, Charlie, and our daughter, Deborah, from bad things that may happen to them after we're dead? And what kinds of bad things are we worried about that may happen to them that we'd want to protect their inheritance from? There's really a couple of things. Number 1 is we're worried that Deborah is married to that slimeball in-law that we never liked. He's lazy. He's never worked a day in his life. Deborah's always had to provide. We've never liked him, okay? And so we're worried now that she has inherited this big chunk of money from our estate because we're dead, that her slimeball husband is going to leave her because he sees his eyes on this million. He thinks, well, if I divorce her, I'll get half of it in a community property estate. So we're worried about divorce with our kids. We're worried that they may get divorced and they lose part of their inheritance. I know for me, if I was dead and my daughter was married to this slimeball son-in-law that I never liked, I would roll over in my grave if I knew he was walking away with $500,000 in this case, $500,000 in community property estate. You know, all that time, all that energy, all that effort, all that sacrifice that I put in to accumulating this nest egg, now, you know, $500,000 of it's going to go to a son-in-law that I never cared for or liked. And so how do we protect my daughter, Deborah, from her husband leaving and getting any of that money? Well, we leave the inheritance inside what's called a legacy preservation trust, an LPT. A legacy preservation trust just means that when my wife and I die, or if I'm single, I die, and the inheritance goes to our children, we never just give them the distribution outright and free of trust. Instead, we give them the distribution in the form of a trust. So when that $1 million comes down to Deborah, it goes into a trust for her. And maybe we structure it so she is the trustee and the beneficiary. She can manage it, she can control it, she can use it, she can access it. But if she gets divorced, the divorce court has zero jurisdiction over that trust because it's not her money technically. It's owned by a trust, not by her. And therefore it's not part of the divorce. And so that would protect it in a divorce. Hopefully that made sense on the divorce. The second thing we'd be worried about with our kids, something bad happening to them, would be creditors coming after that. So I don't know if you guys remember this, but in 2008, the United States tanked. A lot of people lost their jobs. Bankruptcy rates went up. And so lots of assets were depleted in 2008. And so we're worried if our kids go through a bankruptcy after we're dead, that this hard-earned money that we spent all this time, energy, and effort accumulating is going to be going to our children's creditors. So let's say 10 years after I die, or my wife and I die, if we're married, Charlie, who's got a great job, loses his job, right? We go through another recession, people are declaring bankruptcy, no fault of his own, he loses his job. And he has to declare bankruptcy. Well, we'd want to protect that $1 million inheritance from his creditors being able to come in and take his inheritance. This may be the only thing he'll have left to live off of. Now, when he declares bankruptcy, they're going to take his house, his car, his checking, his savings, most of his assets. But what we can protect is his inheritance if it's in the form of this legacy preservation trust for him. And that would shield and protect those assets in a bankruptcy. So hopefully that made sense. The third thing we're worried about happening to our kids would be a lawsuit, okay? So Deborah's driving down the road 5 years after my wife and I have died, gets in a car accident, hits the school bus, and gets sued. What we'd want to do is make sure this $1 million that's gone to her is going to be protected in that lawsuit. How do we do that? We make sure that her inheritance goes into this legacy preservation trust, and we can shield and protect the assets from that lawsuit. So once again, how do we protect our children after we're dead with the inheritance that we're leaving behind to them? We leave it in the form of a trust. It's called a legacy preservation trust. And that way we shield that from these bad things that may happen, okay? Also, these trusts will continue on in perpetuity. So let's say that Charlie has 2 children and Deborah has 3 children. So how we would structure this is to say if Charlie dies, right? So I'm dead, my wife and I are dead, and 15, 20 years after we're dead, Charlie dies, and there's still money left in his legacy preservation trust that he didn't spend. Then where does that money that's left go? Well, we could say it goes to his children in what? Legacy preservation trust to protect our grandchildren from the same bad things that may happen to them down the road. And the same thing with Deborah. We could say if Deborah dies, her share goes to her 3 kids. Or we could say maybe we don't like these grandkids. Maybe they never write, they never call, they never come and visit. So we want Deborah's $1 million, if she dies, to go over to Charlie, or maybe to Charlie's children. But we want it always to be in the form of trust to protect it from this stuff over here that may happen. So that's how we can protect and shield those assets after death occurs. A lot of times when we're reviewing trust, we find the trust or the estate plan says upon the trustor's death, then the distribution to our loved ones is what we call outright, free of trust distribution. And if it says that, then there's no protection, right? Because what happens is when we die, then our kids just get the money. Here's your check, here's your money. They deposit it in their checking account, savings account, brokerage account. They're driving away from the bank, thinking about all the ways they're going to spend their $1 million. They rear end the school bus, they get sued, the money's gone. Or they put it into a joint account with their husband or wife. They get divorced, half of it can be taken in the divorce. And so by doing this, it makes sure we protect it. So hopefully that made sense. in regards to how we protect the legacy we're trying to pass on to our posterity. Let's go back to our 8 common mistakes list and talk about number 7, not creating, updating healthcare directives. So let's go back to our whiteboard. It's now probably more important than ever that your healthcare directives are all updated. We used to recommend that your healthcare documents were updated at least every 5 to 7 years. And that's just because healthcare providers would sometimes not accept them if they were too old, like your doctors or hospitals and stuff like that. And so every 5 to 7 years, we'd say, hey, it's probably time that we updated those just to make sure that the hospitals and doctors will accept them. But now, because of COVID and what's happened with the pandemic, we've actually added a lot of language to our healthcare documents that we didn't used to have, because we didn't worry about that kind of stuff. Really, the main thing is if you are admitted to the hospital and you're quarantined, your loved ones can't come in and see you, they can't talk to you, so you can't check in on them. And so now we've added lots of language about being able to communicate virtually through Zoom and FaceTime and all these other ways that we have, and allowing the doctors to communicate in that same way. Under HIPAA laws, doctors are really hesitant, used to be really hesitant to communicate in those forums, and now we've made it, put that provision in our healthcare powers of attorney that we can communicate in those ways and get that information from them. So I'm going to erase maybe this stuff over here. Is there a way to move this picture? No. Well, that's fine. Yeah, I was just going to do a diagram up here. So I'm going to erase just a little bit of this. I know it's pretty artwork, but I'm going to create some more room here. So your healthcare directives. There's 4 healthcare directives that all of you should have. I should really say there's really a 5th thing that goes with that that we just started doing. If you haven't had your healthcare directives updated within the last 3 years, you're probably missing 1 or 2 of these things we're going to talk about. So might be a good idea just to come in and have us check and see if everything is up to date and working like it should. On top of that, with the COVID thing, once again, we've updated these documents anyway and added a bunch of language that you wouldn't have in your documents. So the first healthcare documents everybody should have, the first one is your healthcare power of attorney. And this is the legal document that says this is the person that can make all of my medical decisions for me. So if I am in the hospital, I've got COVID, I'm on a ventilator, I can't communicate, maybe they're getting ready to put a trach in or something like that, this is the person that will tell the doctors what to do. Very important we have this document. If we don't have a healthcare power of attorney, or it's not updated, doesn't have current language in it, it can cause a lot of problems. The biggest one being that we have to go to court, we have to get a guardianship issued over you that allows somebody to make medical decisions, which means we're paying attorney's fees and court costs and hearings and all this junk that goes with guardianships. So having a healthcare power of attorney is going to solve a lot of those issues, on top of making sure that you have the right person in charge making the decisions for you. Now, with any of these documents, before I continue on, it's very important not only that we create the document and that they're drafted right and have all the right language in them and everything, but we also have the right people in charge, right? So we want to make sure that you've picked the right person. You also typically are going to want a primary person and at least one backup in case something happens to the primary person. And then the next best thing to do is to communicate to your agent who you picked what you want to have done. So yes, the documents kind of spell a lot of that stuff out, but certain things you may want to just sit down with your agent on and have a candid conversation with them. This is what I would like, this is what I wouldn't like. If there's certain assisted living facilities or group homes that you've checked out, that's where you'd like to go. If you had Alzheimer's or dementia, those are things that you should communicate to your agent so they know that stuff. Makes life a lot easier for them. So healthcare power of attorney is our #1 document. Make sure you have it in place, make sure it's updated, it's got all the current language in it, and it's working like it should. The second healthcare document everybody should have is called a mental health care power of attorney. Okay, attorney. So in Arizona, we actually differentiate between health care and mental health care. Okay, so mental health care is when I'm suffering from some type of mental illness. Let's say I have depression or anxiety or bipolar or schizophrenia or any other mental illness that we may suffer from. And I stopped taking my meds, right? I locked myself in my bedroom or bathroom and threatened I'm going to commit suicide because I stopped taking my Prozac for depression. Then we want a mental health care agent that can step in and commit us to a partial psychiatric hospitalization program so we can get back on our meds and get better, and then we can be released. If all we have is a health care power of attorney, no mental health care power of attorney, and our loved ones try to admit us to a partial psychiatric hospitalization program, they won't allow us to be admitted. So in Arizona, we have to have a mental health care power of attorney. So a lot of you have neighbors that have moved from other states, California, Indiana, Minnesota. When you're having dinner on Friday night with them, ask them that question. Do you have a mental health care power of attorney? Kind of a weird conversation to have, I know. But a lot of states, they don't differentiate between healthcare and mental health. Arizona, we do. Very important that we have that separate document in place. The third document we need to have for healthcare is called HIPAA, Health Insurance Portability and Accountability Act. So HIPAA. So HIPAA, all of us know what that is. Anytime you've gone to the doctor or hospital, you have had to sign a HIPAA form. It's one of the 50 forms you fill out on the clipboard when you're at the hospital waiting to get admitted or the doctor's office. And what it does, it says, I hereby authorize the doctor's office or hospital to release my medical information to da 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 da. I have a list of people. And so you've signed that, and it allows them to release your information to other people that need to take care of you. If you don't sign the HIPAA form and they release your medical information to people that you have not authorized, they can be sued. It's a violation of HIPAA rights. Well, what happens if when you're admitted to the hospital, you're incapacitated? Let's say you're driving down the freeway, get in a car accident, you're unconscious. If you're unconscious, you cannot sign a HIPAA form. You're unconscious. So what we want to do is have the HIPAA form signed ahead of time that says, I hereby authorize the doctors and hospitals and nurses else to release my medical information to the following people: my trustee of my trust, my power of attorney, my mom, my dad, my brother, my sister, my wife, my kids, whoever. And so they're on the HIPAA form. It's already in place. It's pre-signed before you even got in the car accident and are incapacitated. And now, if any one of those people that are on your HIPAA form wants to know what room number you're in, what condition you're in, what medications you're being given, who the physician is, they have access to that information. Looks like our internet connection is unstable. Hopefully we don't lose our Zoom call here. If we do, I'm sure we will, one of you will let us know in some way. So that is our HIPAA form. Very important that we have that in place, and it's up to date with that. So very important we have that. Fourth one is your living will. Okay. So what is a living will? So most of you have heard of the Terry Schiavo case in Florida. And if you haven't, what happened in that case is we had Terry, who was in the hospital, and she was incapacitated. She was in a persistent vegetative state, and she had a husband and her parents that were arguing about whether she should be kept on life support or not. And her husband kept saying, you know what, I know my wife. I've been married to her. We've had conversations about this. And she always said she did not want to be kept on life support. She wanted to be removed from life support. And her parents said, we know our daughter, we raised her from birth, we know what she would want. She would never want to be removed from life support. She'd want to be kept on life support. And so we argued and we battled, and there were lots of court cases and many, many appeals, millions of dollars spent, taxpayer money. The governor of Florida got involved, Governor Bush, the president of the United States, his brother, George W. Bush, got involved in a very intimate matter, something that governors, courts, well, lots of people should never have been involved in. And so had Terry had a living will that she had signed before this had happened that said, I do want to be kept on life support, or I do not want to be kept on life support, then there'd be no question about what she wanted, right? she would have made that election ahead of time, and would have saved a lot of time, a lot of energy, a lot of effort, and certainly would have kept everything private in a very intimate situation. So we should all have a living will that outlines whether we want to be kept on life support or we don't want to be kept on life support. The fifth document that we just started doing that I was talking about is an attorney certification. And so we started doing these, I want to say probably 2 or 3 years ago. Attorney Cert. Basically what that is, it's a document that I sign as your attorney that says we are the law firm that drafted these 4 legal documents. If the hospitals or doctors' offices have questions on how to interpret that legal document, if there's a clause and they're like, I don't know what this means, or what are you trying to say by what this clause says, they can contact our firm and we'll explain the document to them. I know they should understand it, it's their profession, but you would not believe how many times these documents are misinterpreted, especially when you die. So under Arizona law, the one that has the power and authority to make your burial decisions or your cremation decisions is your healthcare power of attorney. And a lot of times the funeral home will say, we need next of kin to make decisions. Is she going to be buried? Is she going to be cremated? Well, that's not true. Under Arizona law, it's not next of kin. It's not your brother Kenny who lives in, San Marcos. It's your healthcare power of attorney that has authority to do that. And so we want to make sure those people understand they can contact us. We will explain the law to them and help them understand who is in charge and how the document is supposed to be interpreted under Arizona law. So those are your 5 key healthcare documents that you should have in place. Once again, up to date, make sure they're drafted right, make sure you have the right people that you want to have in charge, make sure you have a backup on these documents in case your primary agent becomes incapacitated or dies. And then because of COVID, you probably want to come in and let's update the documents with the new language that we've added to them, making them more robust, dealing with the issues that we're facing today with this pandemic. So those are our healthcare docs. Let's go back to our 8 common mistakes here. Getting this wrapped up. We might get finished early today. Hopefully that doesn't upset anybody. Number 8 here is family is unaware of plan or duties. So it doesn't really do us any good to draft all these documents. You spend a lot of money. You put some time into making sure all this stuff is done how you want it to be done. You've done all this to get this nice binder put together, but nobody knows where to find it. And so I tell you this because when you're in my position, when you pass away or become incapacitated, Alzheimer's or dementia or something, and your kids or loved ones, whoever it is that's going to be your successor trustee, comes in and sits in my office, you wouldn't believe a number of times they're sitting here saying, I can't find their estate planning document. They told me to call you, Dave, and they gave me your card, and they told me to reach out to you if they died or became incapacitated. So I'm doing that, but I can't find their original binder. I don't know where they put it. I don't know where they kept it. Doesn't do us any good to have created this thing, drafted it all, spent the money you spent to create it if we can't find it. We never keep originals. We've never kept originals, not when I was with my old firm, not now. We've never kept originals. You have your original documents. That's another thing we often find is when you come in to review the document, that's what I ask you, where's your original document? And a lot of times people will say, I don't know, you never gave me your originals. Yes, we did, you have them. You have to find them. Your originals are in your possession. You need to make sure you know where they are, and you need to make sure that your loved ones know where to find them, so that when you do become incapacitated or die, they can locate them, bring them in, so we can help them administer the documents that you had put into place. So number 1, after your documents are created, you've drafted them, everything's in place, you've funded the trust, you've gotten all your assets into the trust, wherever you're going to put that binder, and my suggestion is in a fireproof safe inside your house. A lot of times clients will say, well, what about a safety deposit box at the bank? It's not a bad alternative, as long as you have one of your kids or loved ones or your successor trustee on the safety deposit box with you. And this is why. If we put it in a safety deposit box and the safety deposit box is in the name of our trust, or it's just in our name, it's going to take 3 to 4 weeks to gain access to that safety deposit box, which means we don't have access to legal documents for a month. Why does it take that long? Because we have to get a death certificate showing you died before we can gain entry. And so typically putting in a safety deposit box, not the best idea. Once again, the best place is in a fireproof safe inside the house. And then just let your loved one know, this is where our estate planning documents are. They're in the fireproof safe in the bedroom or closet. This is the password to get in. This is where the key is to access the lock. And they know how to gain entry and access the legal documents. The other thing to do, and we've kind of already talked about this, is make sure that you've kind of explained to them and described to them what their duties are. What are their responsibilities? You know, you don't have to go into meticulous detail saying every little thing they're going to have to do, but kind of give them a general overview of this is what you're going to be doing. Remember, with your healthcare stuff that we talked about, it's very important to sit down with your healthcare agent and talk to them about, you know, do we want to be kept on life support? I know your living will is going to give those directions, but it's also important to just have a candid conversation about how you feel about that and what you would like, along with long-term care. You know, a lot of times you as a parent gets Alzheimer's or dementia, and the kids are scratching their head saying, I don't know where to put mom or dad. I don't know, you know, they want to be in a group home, they want to be in assisted living, you know, what place would they prefer? Well, if you've kind of already gone and looked at places and you feel comfortable with a certain place that you've looked at, have that conversation with your healthcare agent so they know where you'd want to be and where you feel comfortable if that event ever occurred. For your trust, make sure they understand your trustee, make sure they understand their duties as the trustee, make sure they kind of understand, hey, this is how our trust works. This is what happens when one of us dies. It splits into this AV trust. And this is what happens when both of us die. It's kind of going to be split into these sub-trusts for our beneficiaries to protect them. And these are our goals. This is what we'd want you to do as far as carrying out the terms of our trust document. I always recommend and suggest that if your kids are here in town, or maybe they're going to come in for Thanksgiving or Christmas or something, bring them in, right? Schedule an appointment, have them come in and sit down with me. We'll take an hour and we'll just go through the document and say, okay, this is mom and dad's document. This is what it looks like. Johnny, you're the one that they've picked to be the trustee of the trust. And this is kind of what you're going to be doing when death or incapacity occurs. And Judy, you're the healthcare agent, and this is kind of what that's going to entail if you have to take over and start making medical decisions. So take advantage of that. Once again, we don't charge for consultations, so just come in, bring your kids in, happy to sit down with them, explain to them kind of how your estate plan works, and go into as much detail or as little detail as you want. We don't have to talk about the size of your estate. We don't have to talk about who's getting what and what the dollar amount's going to be, but just kind of generally understanding how things will work will help a ton after you passed away. The last thing really is on number 8, when we talk about discussing your estate plan, telling them where to find it. But I cannot, and I say this all the time, but I can't say it enough, to be honest with you, is to just be organized, be overly organized. You cannot be too organized because when you die, you have to remember if it's your surviving spouse, very emotional time for them, right? You've been married for 40, 50, 60 years, some of you, and your best friend has just passed away. The love of your life, the person you've spent every minute with, is now not there. It's very emotional. You're dealing with all these emotions. Your kids are coming in, your grandkids are coming in. You're trying to take care of the funeral. You know, your kids are needing to be talked to, and they need to be consoled, and so you're dealing with all those emotions. At the same time, you're supposed to be taking care of this trust and the legal documents and the paperwork and the finances and IRAs being rolled over and life insurance being liquidated and removing spouses' names from accounts and all that. So the more you're prepared for that and you're organized, then the easier it is when that event does occur. So get as organized as you possibly can right now. Try to get as many of your affairs in order as you can. If you want to come in and talk about what steps you can take to get organized, I'd be happy to do that. We have had webinar presentations on what we mean by getting organized and steps you can take to get organized, and we can certainly do more of those. If you'd like us to do that, just shoot us an email or leave a comment. We'd be happy to do another webinar on what it really means to be organized when death does occur, so that the surviving spouse or your kids or whoever's going to be in charge of this whole thing, it's easier for them, and you've made it easier for them by getting organized today. So those are our 8 common mistakes. We spent about 45 minutes. We usually do about an hour or so. If there are any comments, please feel free to put your comments in, and we will address those. Your comments there's a little blurb in the chat on your Zoom. I'm not sure how many of you are familiar with Zoom, but you can just type those in. So we'll just leave a couple minutes here, see if there's anybody that has a question or a comment. And if there's not, then we will end our Zoom call. Looks like I did a great job.
Good, thank you.
Oh, thank you. You're more than welcome. Thank you.
So, first, I'm drawing.
All right. Well, before you drop off, like every webinar that we do a drawing. And Elisa just reminded me that we need to do our drawing for the month of May. So we have names in our cup here. We're going to do a drawing for our gift basket, right? So those of you that, some of you on here have probably received one of our gift baskets before. Hopefully it was nice and you liked it. Feedback that we've gotten is that they're really good and we have liked them. So we're going to draw one here, which I'm going to have Elisa draw. You pick. Whose name?
Kyoko Morton.
Kyoko. All right, Kyoko. So we have the gift basket. We'll have the gift basket
I'll reach
here.
out to her.
Oh, and Elisa will reach out to you, Kyoko, and schedule a time you can just drop by in the office and grab it. I know you're close by to the office. So congratulations, Kyoko, and look forward to seeing you. And we'll have that gift basket ready. Any other questions? We got another comment. It's just great as always. Thank you very much. More than welcome. Happy to do it. And we'll continue to do these every month, and hopefully they're helpful to you guys. All right. If there's no other questions, we're going to end our Zoom call. Thanks again, everybody. Good to be with all of you. Hopefully pretty soon here, as vaccinations start to happen more and more, we're going to be able to do these in person. And be able to see all of you in person again. And I can't wait to do that. But hopefully all of you have a good summer, and we'll see you next month. All right, bye-bye.